It is 6:30. I'd like to call this meeting of the Public Works and Safety Committee to order. First item on the agenda, approval of minutes. Do I hear a motion?
Second.
Motion by Carlton, second by Barbara. All in favor?
Aye.
Okay, and then next item is Exhibit A, resolution in support of Central Arkansas Planning and Development District for providing grant writing assistance to Hot Springs Village. Do you hear a motion on that?
Second.
A motion by Keith, second by Barbara. Any discussion?
And the gist of this is, there is a capability at CAPDD to do grant writing. The village does not have a true grant writer, like we may have, or cities may have. And they are eligible for certain grants, whether it be police, fire, and now into the water, wastewater, and broadband type stuff. So this gives them access via Saline County to use the grant writers that are already sitting there at CAPDD.
Keith, is there a cost to it, to use that?
No, I mean, we get no cost, we pay into that every year, and the county has used them in the past.
I just didn't know if it would be
Yeah.
to them.
Okay, any other discussion? All in favor?
Aye.
Any opposed? Okay, that concludes our agenda. I believe Keith had something he wanted to discuss.
Just to follow up on the shooting range, remember we had a good discussion about shooting range last time? It sounds like there may be a connection, we won't get it in Saline County, but I've hooked up that individual with the Garland County Shooting Club that has excess land capacity, so it may occur just over the county line. So I just want to give people updates that we may have lost that in our county, but that type of shooting range, clay shooting, may actually still happen. So they're working to see that works out.
Anything else? Do I hear a motion to adjourn? Okay, we are adjourned.
All right, I want to call the Finance Committee to order. First on the agenda is approval of the minutes. Got a motion by Barbara, second by Rick. Any discussion on the motion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Exhibit B, this is a ordinance that we had on the last Quorum court meeting. We made a motion to re-refer this back to this committee because there was some strong discussion on it and some issues with it. At this time, I'm going to recognize Judge Brumley to talk about it.
Thank you, Mr. Chair. I want to walk through this a little bit, just kind of describe what it is not and what it is, and then at the conclusion make a recommendation, a request, if you will. I want to start off by saying that I believe that we benefit as unincorporated areas of Saline County from not having zoning. And I look forward to continuing to benefit from not having zoning. So in the spirit of talking about what this is not at all a desire to ever enter into. Let me rephrase that. This is not a desire to enter into any sort of zoning map, planned use for land, or any other articulation of zoning that because I'm not an expert on zoning, I'm unfamiliar with. I've become more familiar with some verbiage that is synonymous with zoning. And we did meet with the planning board. And we asked that they submit to us any language that needs to be struck from this ordinance. The ordinance came about when it was recognized, from 2000 to 2020, we grew 40,000 in population. We had some rules and regs that the planning board uses as their guiding light that were written in 2008. I wasn't around in this capacity in 2018, but we were informed that in 2018, it was discussed, considered, and agreed upon that the rules and regs should be looked over and considered. Do we need to change them? Do we still go by best practices? And for a number of reasons, just was not able to get much traction. And there was discussion that objectivity is important. When somebody is kind of coming in and assessing the rules and regs, but it doesn't substitute for local expertise and knowledge. So I fast forward to an ordinance that was written with language that was struck, and I'm actually going to go through a little bit of that was struck. That Saline County Quorum Court has previously discussed the need for a master plan associated with the Saline River. As you know, you all approved for us to look at a strategic master plan on outdoor recreation that had to do with the Saline River. But by us coupling an RFQ, a request for qualifications, and the thought that somebody may be able to come in with a high degree of qualifications to help us out on the assessment of the rules and regs, might also have the expertise for us to have dialogue about the other project, was not the right place to couple these. So it was struck. Also struck from this was in the initial fifth whereas, it says, but is not limited to such services as land use planning, site master planning and design, and park and recreation system planning. All of that was struck in the resolution that you find in front of you. Tonight, I want to point out that in Article 2, an RFQ, a request for qualifications, that would be sent out because, County Attorney, I'm gonna lean on you here, hopefully not too hard. Because as it says above, the qualifications are going to be broadened past that of just architects and engineers, but others that may be qualified for the things in which we are asking, in which we can enter into dialogue and they can see what it is that is important to us, which is certainly rules and regulations currently, and give us some negotiation power as far as how much that's cost. As opposed to an RFP, which we put out pages and pages of really what we're looking for without the dialogue that's out there. We want to enter in, stakeholders be able to talk to those that submit to the request. With that, the input from the Saline County Quorum Court and the Planning Board would go over these to make sure we may decide that there's nobody that submitted through our RFQ for our request for qualifications that interests us at all. But we'll be able to say that we did. If we find somebody that did, it would be graded after careful consideration by the stakeholders that are important, including citizens, including developers, including the planning board, including this committee and the court and the county judge, to go into a grading system that would include a planning board member, the county judge, and a member from Saline County Quorum Court. My request to you tonight is to consider this, but to consider removing Article 3. Now, I understand what that does. That means that it'll go to the planning board for some discussion and make sure that we're still okay there. And then if it comes out of this committee, it will be read at the next Quorum Court, and if the next Quorum Court, and then the third Quorum Court to see if it's passed or not. While the spirit was, hey, 2018, let's get on with it. It's probably hard to articulate that there's an emergency if we've waited that long. If I can be completely candid, there has been much discussion in the community much of which has made it to me. We're trying to be as thoughtful, I'm trying to be as thoughtful as I can in explaining this and giving my request for you to consider pulling Article 3 tonight.
Does everybody understand? Any questions? Go ahead, Rick.
What kind of money are we talking about to do this, what you're wanting to do?
I won't be able to answer that until we get any submissions. I wish I could. This is,
50,000, 100,000, 20,000?
I have never done this before in my entire life.
Here's the thing, because what I gathered from the planning board meeting last month too, the only thing that they were really concerned about was writing some rules for commercial development. They seemed like they were really happy with the residential plans that they already have in place. So if all they need is to tweak their commercial development, do we not have people on the planning board that could look at some other counties' commercial plans and say, we like this idea, we don't like this idea, let's adopt this, and for a heck of a lot of money, do our own in-house study and come up with something without spending X amount of dollars?
To go back, I can't remember exactly what I said, but I gave a very uneducated guess at the planning board, and I think I said $25,000. Talk about pulling it out of the air, that's exactly what that was. We found ourselves, the Saline County, in a pretty precarious situation in regards to the definition of subdivision, which was a residential definition. I didn't stand in front of the circuit judge, but I'm gonna paraphrase what I was told. You were this close, Saline County, because of the ambiguous nature of your definition. It needs to be rewritten. 2018, somebody decided they needed to be assessed. We're in 2023. Not throwing anybody under the bus, it just hasn't been done. We've grown a lot since 2018. I believe it deserves an objective look. We may never get there, but what we're asking for now is to be able to just simply put out an RFQ to see what's out there, to be considered, to be able to talk about those things so we can educate it, not an educated guess, but with what you all want, you're looking at it costing about this much money. But right now, I wish I could answer that question.
Well, let me tell you this, I appreciate you taking the language out with the planning and development and zoning and all the other things that were in there, because that is not what we would ever need in this county, I don't think. I still have lots of questions, and I like you, I'm no expert either, I have to rely on other people, so if we were willing to take the emergency clause off, we would have an opportunity to discuss this and read this 3 times, that I could see being in support of something like this, so we can get out and see what's out there. I understand that. But I want to be clear, I don't want anything rammed down our throats as far as having to build parks or bike trails or anything like that in the county.
Yeah, Rick, I don't think, this is not gonna drive bike trails or parks or,
This is not the RFQ that was tabled at the last meeting either.
yeah, this is a
That's
skinny,
what I'm saying,
yeah,
so.
this is a skinny down one to focus on very specifics, out there and get someone outside to give us a look. We might be perfect, I don't think so, but we may be. But it's always nice to have someone give us a look, and then the expertise that we have internal for the county is that interface too, because that's where now with the 3 readings, it would allow that, 3 months to work through this. Hopefully, the biggest thing is we've changed. You see it on your, we see it on our side of the county.
Yeah.
Pat sees it on his side of the county. We're so used to the bent and grind. But gosh, on the ends of the county, things are changing out there. And we may have to do some tweaking. We don't know.
Well, again, as long as we keep control of it, and that was one of the other things that came out of the planning board too, that, they're willing to look at it as long as they can say, no, we don't want this, or yes, we do. But they also mentioned that the last time that they did something like this, it was somebody like Metroplan, I don't know that it was Metroplan, but somebody like Metroplan that wrote them a big document on what to do, and they looked it over and said, yeah, this is trash. And that's the last thing that we need to do is waste money like that.
Well, and that's key, because as you go through the RFQ and you find, then you're gonna have to do an RFP. And we gotta be very specific in the RFP, so you don't get that big, trashy document that you throw in there. The village went through that 4 years ago, spent $500,000 on a plan. And it got into that, and the big 100 pages just got thrown away. I understand.
Okay.
Mr. Bellinger, if I may, I want to be clear on this. This does not transfer nor substitute any authority. We have the planning board in place for a very specific reason as subject matter experts. And we want to keep that just as we do Quorum Court members. There's nobody coming in telling us what to do.
Thank you.
Alright, everybody good? We got the questions answered? So, if the will of the body wants to accept that recommendation, you need to make a motion to amend, or to amend Article 3, or just strike Article 3, and strike emergency at the top of the ordinance. That would need to be the motion to do that for approval.
I'll make the motion to do both, strike emergency and strike Article 3.
Okay?
Second.
Does everybody understand what we're voting on? Does everybody understand, the amendments? Okay, we can do the amendment and approval at the same time. Any discussion on the motion? All those in favor of the motion say aye.
Aye.
Any opposed? Motion carries. Exhibit C, resolution. Do I hear a motion? Motion approved by Keith. Second by CJ. Any discussion on the motion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Exhibit D, resolution, stop grant application.
Move to approve.
A motion by Pat, seconded by Jim. Any discussion on exhibit D? All those in favor say aye.
Aye.
Any opposed? Motion carries. We have 2 action items on the agenda that HR approved. Finance needs to approve them. I just need to hear a motion to approve both action items.
Move to approve.
Have a motion approved by Keith, second by Barbara. Any discussion? All those in favor say aye. Any opposed? Motion carries. At this time, we have more public comment.
We're gonna do our comment first.
Yeah, we can, any comment by the Quorum Board? Sorry, Keith.
Okay, one comment that I have, and it's a question I have. Do we have any ordinance or anything in the county books that deals with harassment of county employees?
I've pumped that one to our county attorney.
I'm not aware of any off the top of my head.
Because I mean, unfortunately, after the last Quorum Court meeting, there was at least 1 or 2 incidents outside. And I get the feeling from dealing with the situation in my district with a road issue that probably there's a county employee that's taken enough grief over something. I just wanted to know, where we stand and what we're going to do. Is there a state law or anything? Because, we got maybe some county employees out there that put in a bad situation. I just throw it out there for comment. So,
Obviously, there's some state criminal statutes that pertain to harassment and things of that nature. Now, whether these interactions would rise to that level, that would be a question probably for the prosecuting attorney, probably depending on the facts and the circumstances.
Thanks, Keith. Any other public comment from the Quorum Board? All right, now I'm gonna go to public comment. First on the public comment sheet is Brian Nally with Saline River Watershed Alliance. Mr. Nally, just recognize your, state your name and your affiliation, and you will be recognized.
It's Brian Nally. I'm just here to speak on behalf of the river. I'm a Saline County resident, but as this board, this Quorum Board and Planning Board considers any regulations or any changes to the planning board, a couple of points to consider is, in 2006, there was a study on the Saline River, and 81% of the property in the upper Saline Basin was either forest or pasture land. That was 2006. As that changes, things are gonna be changing as far as the river's concerned. And consider during the process of getting your RFQ and studying these things, consider this. Just a couple of things to think about. There's approximately 1.1 million acres in the Saline River Basin as a whole. There's approximately 440,000 acres in the upper basin, and that's from the bridge north. Last Saturday, there was a 1.3-inch rainfall in Saline County in a 6-hour period. So, I had my 10-year-old grandson help me calculate this. But anyway, at that much rainfall, 1 inch of rainfall per acre is 27,000 gallons of water. And if a 1 inch rainfall fell on the upper Saline Basin for 6 hours, that's 1.2 billion gallons. So think about this picture, a drop of water falling out of the sky. If it lands on trees and shrubs and bushes, or if it lands on asphalt, rooftops, curbs and gutters, which one's gonna get a faster runoff? And then think about 1.2 billion gallons of water going down the Saline River in a 6-hour period. What does that do to the stream banks and the amount of silt that enters in the river? Now, I've listened to this board, this Quorum court, and you guys are real logical people, and just take under consideration as these regulations are looked at, take into consideration what we can do to slow that stormwater down in any way. So that's what I gotta say.
Thank you, Mr. Allen. Next up is, I believe this is Eugene Jamison.
I'm Eugene Jamison, I'm just a citizen here. I want to thank the Quorum Court for allowing me to speak. On April 27th, an article was published in Saline Courier by the Community Engagement Manager of the Saline County Library. While there are several things I disagree with, I'm going to focus on 2 statements made. The author stated in the article, even after Act 372 goes into effect, the library will continue the current selection criteria and policies in place to purchase material for the library, since the library does not purchase judicially obscene materials. And in another statement, in order to adhere to a constitutionally granted right to the First Amendment. First, let's debunk the First Amendment statement made. According to the U.S. Department of Justice website, obscenity is not protected in the First Amendment right to free speech, and violations of federal obscenity laws are criminal offenses. The U.S. courts use a 3-pronged test, commonly referred to as a Miller test, to determine if given material is obscene. Obscenity is defined as anything that fits the criteria of the Miller test, which may include, for example, visual depictions, spoken words, or written text. The 3-pronged Miller test is this: 1, whether the average person applying contemporary adult community standards finds that the matter taken as a whole appeals to the prurient interest. 2, whether the average person applying contemporary adult community standards find that the matter depicts or describes sexual conduct in a patently offensive way. And 3, whether a reasonable person finds that the matter taken as a whole lacks serious literary, artistic, political, or scientific value. Furthermore, the standard of what is harmful to minors may differ from the standard applied to adults. Harmful material for minors include any communication consisting of nudity, sex, or excretion that, 1, appeals to the prurient interest of minors, is patently offensive to prevailing standards in the adult community with respect to what is suitable material for minors, and lacks serious literary, artistic, political, and scientific value for minors. Members of this Quorum Court have been shown books whose material I think all of you consider obscene, especially to our children. I believe the Saline County Library and its employees that willingly purchase and distribute this obscene material to minors should be held accountable under these obscenity laws. The Saline County Library is managed by Saline County. They are county employees. I would suggest the legal liability to Saline County should be something the Quorum Court should be very concerned about, especially since they have said in print they are not planning on changing their policy even after Act 372 is enacted. We must reject these evil forces trying to indoctrinate our children under the complete farce of inclusivity. We have laws in place to protect children from this evil. We need to hold libraries and their employees accountable. Thank you.
Thank you. Up next, Mr. Gary Beck.
My name's Gary Beck. I'm a Saline County resident, Salt Creek Road, Benton, Arkansas. I thank y'all for your time again tonight, like I did the last time. Would you please use these mics? I'm getting older and I can't hear as good. And I don't know a thing he said a while ago.
That's okay, you don't need to know. I'm just picking on you, Keith. Next up, comes a regular here, Angela Gray.
I'm Angela Gray. On behalf of the Saline County Republican Women, I'm here to thank the court for passing the library resolution last month. Since the resolution was passed, Director Hector has attempted to undermine the spirit of the resolution by militarizing her staff against the Saline County Republican Women and against me personally. They have not only harassed us both in person and online, but they've engaged in a mass disinformation campaign against our organization and the resolution itself. Director Hector has repeatedly told media outlets that she will not remove any materials, despite the resolution and Act 372. The Saline County Republican Women are unmoved by these tactics, and we remain in support of the Quorum Court and the resolution. We are resolved to protect the decency of this community by fighting this matter to its conclusion. As always, I'll be available after the meeting if any of you have any questions. Thank you.
Thank you. Next up, Mr. Aaron Raspberry.
Aaron Raspberry, I'm here to speak on the ordinance on the RFQ.
Hold on, you're speaking on something that's on the agenda?
Just making a comment, you already voted on it.
Right, okay, I'll just make sure you are speaking on something on the agenda.
Yes,
That's what I'd like to
RFQ.
hear. All right, thank you.
Yes. So, just to address a couple things, in 2018, there was a committee formed to take a look at the rules that were drafted beginning in 2008, which I, as your county surveyor, was a part of. And on that committee in 2008, I was also on the committee in 2018, where we started to readdress and relook at our current rules, make some changes, give some updates. The County Planning Commission and myself I've been a public servant for a long time. I'm proud of my community. I love what I do. I make a living based on the rules and regulations of this county. I try, and I have done a very good job, in my opinion, in doing developments across this county, across this state. I've dealt with many planning commissions, from Rogers to Fort Smith, to Pulaski County, Little Rock, to Texarkana. I've seen many of these ordinances written. I've got a vast knowledge of what happens and what some issues are that happen in other counties. Your planning commission has developers, realtors, home builders, people that also make a living in this county that are a huge asset. Other communities don't have what Saline County has sitting on their planning commission. In 2018, when myself and others on the planning commission started to talk about the update on the rules, yes, there was a delay. It was COVID in our meeting. That's what stopped it. Myself and the other board members have offered to look at other ordinances in other counties similar to ours, and to prepare an update like we did originally in 2008, was an update from, I believe, 1996. From 2008 to now, our county has grown. There was a definition that at the time in 2008, 2009, Stephanie Cassidy was our she was an attorney board member. Yes, we all missed something. We tried to, I think Mr. Gruber ran an emergency ordinance through this court, which was approved. Then the lawsuit happened, and yes, Judge Houston did say that just by margin or whatever, it almost didn't go. But this was after an emergency that had already been passed. So therefore, I think in March, I was partially in help of writing a definition that y'all approved last month, which is a lot of my input, And speaking with the
Mr.
board.
Raspberry, your time's up, but I will ask a question. So you are in favor of taking a look into the rules and seeing where we can be better, or seeing where we could make amendments?
By a member of
change?
the community which we serve. By the people in this county that live here, make a living here.
But you acknowledge everything has to be ran back through the planning board and the Quorum court.
The ordinance that is on this paper tonight does not say that. It does not limit anything. It includes, it says, procure planning services, which includes, that doesn't limit a lot of stuff that's very dangerous. You know, you look at what Pulaski County's doing, you look at, you look at the Southwest Trail, for instance. Y'all hire planners, but who knows how many hundreds of thousands of dollars for whatever firm that was to draw the squiggly line down through the county. Doesn't care who or what landowner is affected.
So
I'm gonna
ask Will. So any rules, changes on developments, any planning rules, they have to be approved by the planning board and the
Correct.
Quorum court.
This is merely just authorizing issuing an RFQ for planning services. Doesn't impact what the process would be for any rules changes.
Well, we have 3 months now to talk about it.
We haven't seen any of that. It's not mentioned on this. It says the responses will be graded by a planning board meeting.
Mr. Raspberry, your time's up.
All right, you asked a question.
We have,
Thanks.
I know, we have plenty of time to discuss this in the future. Next on the public comment page is Mr. Jimmy Sorrells.
I'm Jimmy Sorrells. I've been in the land development business for 30 years.
Are you
Different
speaking on
counties.
something on the agenda?
Huh?
Are you speaking on something on the agenda?
I surely
Thank
am,
you.
like I talked on the phone about it.
Yes.
Another time. Our subdivision rules are great. I've done it in several different counties here in Arkansas. I've done them in Texas, but most of my stuff's been here in Saline County, where I live, where I make a living, where my friends and family live. And nothing's better than local input from the people we live with and what we do. You got that skin in the game to make it work. Our rules are really, really good. I know of no subdivision that I'm ashamed of. I don't know if you are ashamed of when it's taking place. But they all have been, if you play by the rules, they're good, just like they are now. You want to beat the system? Everybody beats the system. That's where they got penitentiaries, you know. People beat the rules. That's all I can say. They're good. I don't know why you spend the money or the time when we could do it amongst ourselves. Just more tax money, pay money. It's the only way, I think. Anyway, appreciate it.
Thank you, Ms. Sorrells. I do have to say, Ms. Sorrells and I have been close friends for a long time, and I know several subdivisions that he's done, and he's done an outstanding job. Next up is another good developer, Mr. Alan Strader.
I'm Alan Schrader. I'm, I guess, speaking on one of the topics tonight that these other developers have. I don't know a whole lot about what's got us to this point, other than we do work in this community. We have for a long time and continue to have plans to do that in the future. But my concern would be is this, I think it's been touched on by the other persons, is that we just look at this within, we do have what I think is a pretty good set of rules and regulations when it comes to development and the concerns thereof. I certainly think that the Saline River and all the other assets we have in our county are very beneficial to us as developers, so I personally would like to see those protected as well, but I don't think that's what we're really here for tonight. So let's just look at this and leave control in the hands of the person sitting in this room or in this county, rather than outsourcing these to other entities. That's really all I have. And thank you all for your time.
Thank you. Up next on the public comment is Bart Ferguson. All right, thank you, Mr. Ferguson. The last public comment that we're going to be hearing is Robin Bray.
Same thing as these guys. So when I first read the first ordinance, and I did not know about it before the previous Quorum Court meeting, which I understand the line was out the door for another reason. So I didn't even know about it, but when I saw the previous ordinance, I do appreciate that a lot of that language was changed. Thank you. It does read a lot better. I'm happy that the emergency clause was taken out tonight. I wish we'd been able to put a little more public input into it before we took the vote to do this. The only concern I still have, and I don't know if it's too late to revisit it, maybe y'all can do that, is in the language in 1, 2, 3, in the 4th paragraph, where it says the Saline County Quorum Court deems it necessary to procure planning services, which includes creating design and development guidelines. What you read into that is included but not limited to, and it could be interpreted that way. So for that reason, I would like that to be a little more specific, that it is limited to. And that would make me happy. And I think it might make everybody else feel a little bit better too, going forward, not afraid that we're gonna have to come to every single meeting from here on out to figure out what's going on. So if we could just make that specific, I think that would make a lot of people happy.
It's a living document between now and July. Well, we did take an emergency clause out. We pushed the vote back to the final vote back to July, and it sounds like Judge Brumley's interested in working with all the interested parties and making sure everybody's comfortable with this.
That would be good. I appreciate it. I think that's only my concern is that, well, and I appreciate your intent statement, but 10 years from now, if you're not still here, we don't know how it's gonna be interpreted, if that makes sense. When we're all not here, when our grandchildren are living out there, we don't know how that's gonna be interpreted. So that's the concern. Let's be very specific about what we want to do.
Thank you.
Thank you.
All right, that concludes our public comment. Any other comment by the court? I'll entertain a motion to adjourn.
Mr. Chairman, I would like to make a brief announcement. Pull up the calendar here. On May the 21st, the International Acclaimed Eddie James group will be present at New Beginnings Apostolic Church in Bryant, and we just like to invite anyone that would like to attend. They play a lot of the songs that you hear on the radio if you're listening to a Christian station, and so I just like to invite everyone for that.
Thank you. Any other comment? Now I entertain a motion to adjourn. Motion by JR, second by Rick. We're adjourned.